Welcome back to Judiciary coaching classes. In the first part, we have seen that the general principles of criminal law. There, we have seen what are the essential elements for a crime. Those are: the first one is person, the second one is mens rea, the third one is actus reus, and the fourth one is injury, and the fifth one is object. Later on, we have also seen that there are four stages in the crime. The first one is intention, and the second one is preparation, and the third one is attempt, and the fourth one is accomplishment. I have already promised that at the end of the session, we would do certain multiple choice questions which will quite often come into the judiciary examination. This particular part is very important for preparing the preliminary examination. So let us start to do that thing. These are the questions which have come in the previous year examinations. Again, these will come in a different mode. That's why once we will master these questions, it is very easy for us to answer the questions at the preliminary examination. Okay, the first question is, which one of the following is not essential for an offense? At the time of explanation itself, I told you that intention is also a very essential part. Prohibited act must be there if it has to be treated as an offense, and punishment for act is a natural consequence for the crime. That's why A is correct, B is correct, D is correct. These three are the essential parts of an offense, but motive is not it is not an essential part in an offense. Motive is the key to the intention. Sometimes motives may be very pure. Even then, they may trigger for criminal action. I gave an example that if you want to serve the food for the poor people, but you did not have sufficient money, for that purpose, you rob a bank and bring that amount and serve the poor. Here, your motive is pure, but the act is criminal in nature. That's why motive is not essential for classifying an offense. But police in the criminal investigation always try to find out the motive because it gives the clue for the criminal intention. Here in the first question, the answer is B. Now the second question is, the grounds for punishing Prince in R versus Prince was prohibited act done by Prince, illegal act done by Prince, knowingly committing of civil wrong by Prince, D. Illegal and prohibited act done by Prince. Here, unless you know the case of R versus Prince, you cannot answer this question. So far as these landmark cases are concerned, I told you all of the landmark cases relating to BNS, I will take up 2 classes. In those classes, I explain what are the landmark cases. The settled law laid down there, as well as the simple facts to remember those cases. Here, the prince had taken away 16-year-old girl from the lawful custody of her guardian. He thought that the girl was adult, but later on it turned out to be that she was a minor. In this case, that mens rea, criminal intention was not there on the part of prince. Even then, the court held that in such a cases, just like kidnapping, the mens rea is not an essential thing. That is the settled law at that particular point of time. Later on, courts have changed its position. In our Indian BNS, there are several provisions in which kidnapping as well as abduction, the mens rea is required. But here, the answer is it is not only prohibited act done by prince, it is not just illegal act done by prince, knowingly committing of civil wrong by prince, but the answer is illegal and prohibited act done by prince. This is the important. This is the answer for this question. The reason behind this is the two qualifying things that the act done by prince is illegal as well as it has been prohibited by law because the law doesn't permit any person to take away any minor one from the lawful custody of her guardian. Here the prince has committed that wrong even though he had no malified intention. Next, the third question is, who among us the following observed that under the Indian Penal Code, such a maxim, actus non facit trium, nisi mens sit rea, is wholly out of place. Here, in Indian law, earlier it was Indian Penal Code and it is now BNS. It has been clearly, nowhere it has been mentioned as mens rea. But mens rea we will derive by seeing certain words. For example, intentionally, knowingly, fraudulently, dishonestly. These are the words which would indicate the criminal mental intent. Here, these three others, J.D. Mene as well as H.S. Gaur and Ratanlal Dheeraj, all these three held that mens rea is not a part of Indian law. That's why the answer is all the above. Next one is, which one of the following is not generally an essential element of crime? You see, repeatedly this thing is coming. Actus reus, mens rea, motive, and human being. We have already seen that motive is not an important thing. That's why the answer is C. Next, we will see this thing. Here, the next question is, crime is punishable because it is provided in the law. The reason is crime is not revolting to the moral sense of society. In these days, mostly this type of questions are coming. Assertions and reasons. This is generally a little bit more complicated than general multiple choice questions. Here we have to apply our mind. Crime is punishable because it is provided in the law. It is okay. It is assert. It is the right thing. Crime is revolting to the moral sense of society. Yes, it is also correct because who said this thing? This thing has been said by James Stephen in his History of Criminal Law book. He told that crime must be revolting to the moral sense of society, then only it will become a crime. That's why here the answer is Both A and R are true, and R is the correct explanation of A. This is the correct answer. Next question. In every statute, mens rea is to be implied unless the contrary is shown. This view was expressed in Sharras versus D. Rudgen, R versus Dudley versus Stephen, Harding versus Price, R versus Prince. Again, this is a landmark judgment. Here, the thing what happened is in Sharras, the correct answer is the Sharras versus D. Rudgen. In this case, what happened? A licensed liquor shop was open. In that, a policeman on duty came, but he was not wearing uniform. The bartender served drinks to the policeman. Later on, it came out that policeman was on duty. As per the law prevailing at that particular point of time, serving liquor to the police personnel on duty was illegal. Here, the bartender was not convicted for the reason he did not know that the policeman was on duty and there was no mens rea. That's why in this case, in every statute, mens rea is to be implied unless the contrary is shown. In that particular act that has not been implied mens rea, that's why that accused was acquitted. Next question. Which of the following pairs is not correctly matched? Again, this landmark judgment. That means what we have to understand is this thing. While preparing for the judiciary examinations, we must be quite sure, so far as landmark judgments are concerned, we must read them very thoroughly. And the second type of questions, those will come in the next chapters. There, we have to remember section number and content of the section. These two things will cover about 60 to 70% of the law paper. Here, mens rea is which of the following is not correctly matched. You see, this not, this word you have to remember. Whenever you read such kind of questions, you will be many times got confused. Why? Because sometimes they will give which of the following pairs are correctly matched, and sometimes they will give it which of the following pair is not correctly matched. Whether not is there in the question form, we have to see very clearly. Once you confirm that thing, then you go for answers. Here, the answer is, you see, insanity, McNaughton's, intoxication, Bhadeva website, necessity, baby bird, R versus Prince. Okay. Here, the correct answer is B. Mens rea, R versus Prince, I have already told that taking away the minor. In insanity, McNaughton's case is the landmark case. We will talk about this case when we will deal with the chapter 3. Intoxication of Basdev versus state of Pepsi is very important case. This also comes in the chapter 3, general exceptions. In general exceptions, necessity, intoxication, insanity, these three items will come. Here, the answer is necessity. It is not concerned with the DPP versus bed. Okay. Next question is the essential ingredients of crime are motive, mens rea, and actus reus. Second one is motive, intention, and knowledge. Third one is mens rea and actus reus. Fourth one is knowledge, intention, and action. We have already seen that motive is not an essential element. That's why here A and B are ruled out. Okay. A and B, they are ruled out. Now comes mens rea and actus reus. These two are essential. And the fourth one, D, is knowledge, intention, and action. You see, knowledge and intention are synonymous. That's why it is superfluous. That's why the correct answer is mens rea and actus reus. The correct answer is this thing, C. And this is wrong one, knowledge, intention, and action. Next comes uh, in which of the following offenses mens rea is not an essential element. You see, bigamy, murder, theft, and robbery. This is very important. In the case of bigamy, mens rea is not essential element. In the case of theft, yes, mens rea is required. Murder, yes, mens rea is required. Robbery, mens rea is required. In the case of theft and robbery, these are offenses against the property. In the case of murder, it is an offense against the life. In the case of bigamy, the landmark judgment is R versus Tolson. In that case, a woman was deserted by her husband. After 1 year, she tried to find out his whereabouts. She could not find. That's why she married some other person. After that, her husband had come back. Then a charge of bigamy was laid against her. The court told, even though acquitted in that case, that particular lady, the court told that in bigamy cases, mens rea is not an essential element. With the prosecution shall not be burdened about to proving that mens rea is there to convict in the case of bigamy. That means in bigamy cases, mens rea is not required. Similarly, in the case of rape, mens rea is not required. In kidnapping and abduction also, in most of the cases, mens rea is not required, but in some particular instances, mens rea is required. As and when we see that thing, chapter 6, we will read, then we will try to find out how mens rea is required in certain cases and how mens rea is not required in some kidnapping and abduction cases. But generally, bigamy, kidnapping, abduction, mens rea is not required. Which of the following statement is or correct? Preparation to commit dacoity is not an offense. Preparation to commit murder is not an offense. Attempt to commit murder is not an offense. You see, attempt to commit murder is an offense. It is section 309 of BNS. Similarly, preparation to commit dacoity is an offense. It comes in section 304. Preparation to commit murder is not an offense. Yes, it is a right statement. That's why answer is B. Because preparation to commit dacoity is not an offense is a wrong statement. Preparation to commit dacoity is an offense. It is come in, under section 310, subsection 4. You must remember this thing because this question comes quite often. Preparation to commit dacoity, because while studying about preparation and attempt, there are only a few offenses where preparation is itself an offense. In that, dacoity is there. Next question. Which of the following statements are correct. Preparation to which of the following statements are correct? Mensari are not, yes, are correct. Mensaria is not an essential ingredient of an offense punishable under Section 107 IPC. Mensaria is not an essential ingredient of an offense punishable under Section 304A. Mensaria is not an essential ingredient of an offense punishable under Section 364A IPC. Both A and B are correct. You see, mensaria is not an essential ingredient, an offense punishable under Section 107 IPC. Under BNS, it is Section 45. It is abatement. In the case of abatement, uh, intentionally aiding for abatement is an offense. Intentionally word has been used there. That's why it is an essential ingredient in the case of abatement offenses. Mensaria is not an essential ingredient of an offense punishable under Section 304A. It is under Section 106 of BNS. Okay, it is negligence, causing death by negligence. Okay, causing death by negligence, mensaria is not required. Actually, negligence is the pale shade of mensaria, criminal intent. That's why negligence won't be treated as exactly synonymous to the mensaria. That's why the answer will be mens rea is not an essential ingredient of an offense punishable under Section 304A IPC. In the negligence, mens rea is not required. Okay, next. Mens rea is not an essential ingredient of an offense punishable under Section 364A IPC. That is 140. This is abduction case. In the abduction case, I told you already, in certain cases, mens rea is not essential. But generally, in the abduction cases, mens rea is an essential ingredient. That's why here the answer is B. Next, A is a good swimmer. He sees B drowning, but does not save him. B is drowned. A has committed the offense of murder, the offense of abetment of suicide, the offense of culpable homicide not amounting to murder, and no offense. You see, saving him is a moral responsibility. It is not a legal responsibility. In BNS or IPC, nowhere it has been shown that saving a person is your legal responsibility. It is your liability. If you don't save, you will be punished. It is not there. That's why it is not offense. But in the case of Section 106, subsection 2, which has not been notified till date, there a word is there. If you are driving a vehicle rashly and negligently and causing an accident, causing death, you shall immediately report. Actually, you shall take the injured person to the hospital and report it to the police station. And that is the thing which has been put in that particular provision. But that has not been notified. That's why here the answer is no offense. Because B doesn't have any legal liability to save A. It is only the moral responsibility. Moral responsibility cannot be punished because you have got a plenty of money. A beggar is asking for alms for his food. Then you want to give anything. It is not an offense. It is only your moral. It is your only your moral thing. If you would like to give it or you don't like to give it. Okay. Now we will go to next question. What is the offense preparation whereof is also punishable? Okay, we have already dealt with it. Preparation. At the time of preparation, theft, no. Murder, no. Dacoity, yes. Rape, no. That's why even preparation of dacoity is itself an offense. Assembling in a park to commit dacoity is itself an offense. This thing you should remember because this question is quite often coming. Next, the Indian Penal Code 1860 came into force on so and so, so and so. Answer is 1st January 1862, but this question will not come because now BNS has come. When BNS has come into force? 1st of July 2024. You must remember that thing because that question will come quite often for the coming 2 to 3 years. Okay, which of the following combinations are not correctly matched? Again, this landmark cases. Sharas versus D. Ridgen, Mansoria. I told you about that, serving the liquor to the policeman on duty. Virendra Kumar Ghosh versus Emperor. Intoxication, no. It is not the thing. Abhayanand Mishra versus State of Bihar, right today, no, it is criminal attempt. Gyan Kaur versus State of Punjab, it is right to die. Which of the following is not correctly matched? 2. Answer is 2, 15. 2. You see, Virendra Kumar Ghosh versus Emperor, it is common intention. It is not correctly matched. Abhayananda Mishra versus State of Bihar, it is attempt. That's why it has not been correctly matched. Gyan Kaur versus State of Punjab, it is right to die. It has not been properly matched. That's why the answer is 2, 3, and 4. It is A. Answer is A. In the case of Sharas versus D. Ridgen, Mansoria, yes, it has been correctly matched. Next, we will go. Which of the following is correct sequence of stages in crime? Intention, attempt, accomplishment, preparation. You know, intention is the first stage, preparation is second one, third one is attempt, and fourth one is accomplishment. That's why the answer is B. Which of the following statements is or incorrect? Criminal liability is best explained by the maxim actus non facit reum nisi mens sit rea. In the explanation, I told you two maxims have to be remembered so far as mens rea is concerned. One is this one. For criminal liability, the actus should be reus. The word actus reus only includes act but not omissions. The actus reus of omission is well illustrated in R versus horse. Okay. See here, criminal liability is best explained by the maxim. It is correct one. Second one, for criminal liability, the actus should be reuse. Yes, actus reuse. Reuse matlab prohibited, actus matlab act. The prohibited act. In the law, it should be prohibited. I gave the example of live-in relationship. Live-in relationship is not prohibited. That's why it is not an offense. If a consenting persons go and start to live together, that act, as it has not been reused, that is not an offense. Now, the third one is the word actus reuse only includes act but not omission. No, it is wrong thing. It is incorrect. Only third is incorrect because the act means act as well as omission. For example, And then in the next MCQ, this thing is coming. The actor's use of omission is well illustrated in R versus horse. Yes, in this case, R versus horse. A 16-year-old girl was not provided food continuously by her father. Not providing food means it is omission. This is an offense. Similarly, if a jailer will not provide food to the imprisoned person, then it is also an offense. Omission is also a part of the act. That's why offense includes two things. Offense includes acts as well as omissions. Here the answer only 3 is incorrect because the word actus reus only includes act but not omission. It is a wrong thing. Next thing is the cardinal principle of criminal law. Nullum crimen nulla pena singil legi means no crime or punishment can exist without a pre-existing penal law. It is the correct answer. You see, you have to, these legal maxims, these words have got almost all similar meaning just like in English. That's why we can decipher. Nalla means no crime. Nalla means no. Pena, matlab penal provision. Sine without, unless. Legislature. No crime or punishment can exist without a pre-existing penal law. As on date, if a penal law is not prescribing, means it is not prohibiting any particular act, then no punishment can be given to me because the earlier example I had given it. Earlier under section 377 unnatural offences, homosexuals commit sex, that was at that particular point of time prohibited act. That's why that was an offense. Now it is not an offense because in the existing penal law, homosex is not an offense. In which one of the following offenses mens rea is not an essential element? Again, it has come. Bigamy, murder, theft, robbery. I have not repeated the question again. Actually, this question again and again came in the examinations. That's why it has come here. The answer is bigamy. In the robbery, theft, murder, and all these things, one is against life, and the other two is against the property. Crime is said to be an act which is both forbidden by law and against moral sentiments of the society. Who gave this definition? This definition is given by Stephen. Sir James Stephen. This question may not come in these days. If it comes, it will come only in the jurisprudence. If jurisprudence topic is there, then only this type of question will come. Even then, you remember this thing. Stephen has emphasized that a crime has to be branded when it is immoral. But not all the jurists have said this thing. Which of the following is not an essential element of crime, namely human being, actus reus, mens rea, object? Actually, in fact, all are essential elements. If such kind of question comes, I told in certain cases, mens rea is not an essential element. But while answering this type of questions, we have to apply which is the most probable answer. Human being is an essential feature. Mens rea is also about 90 to 95% of cases, it is an essential thing. And actus reus, unless actus reus is there, there is nothing. That's why it is very essential thing. Object, yes, Object is not a very essential thing in some cases. For example, in the case of traffic violation, to whom you caused injury, you cannot say that state was injured. In the middle of night, you break down the traffic signals. You violated the law, but no one was injured. That was not an offense. That was an offense in legal terms, but there was no object. That's why the answer here is object. In several cases, we will see that there won't be any object, even then offense will be committed. The answer here is object. Next 22. Which of the following statements or statement is or correct? Mens rea means guilty knowledge of the wrongdoer. Indian Penal Code does not neglect mens rea but requires mens rea of specific kind. Offences of kidnapping, abduction are punishable without mens rea. Mens rea is a basic ingredient in crime. Answer is, you see, one, mens rea means guilty knowledge of the wrongdoer. Again, this the most probable answer we are searching for it. Because guilty intention of wrongdoer, it is not knowledge. Mens rea means guilty knowledge. Mens matlab, intention. Rea matlab guilty. Here knowledge is there in the case of intention. That's why it is the wrong answer. Wrong thing, wrong statement. And remaining statements are correct. Indian Penal Code does not neglect mens rea but requires mens rea of specific kind. It is correct. Even in the case of negligence and other things also, mens rea, a shade of criminal intention is required. Similarly, in the case of kidnapping and abduction, we are saying mens rea is not required, and it does not mean that guilty mind is not required. I already told you that prosecution shall not be burdened to prove that mens rea, but mens rea will always be there in every action. Whether it is criminal action or not criminal action, a good thing, a pious thing, a beneficial thing, then also mens rea, intention shall always be there. It is not a mens rea, but intention will always be there. That's why Indian Penal Code does not neglect mens rea. It is correct statement. Offences of kidnapping and abduction are punishable without mens rea. Yes, prosecution shall not be burdened with mens rea. Without showing mens rea, kidnapping and abduction can be proved. Mens rea is a basic ingredient in a crime. Yes, it is true. That's why the answer is C. 2, 3, and 4 are correct statements, but the first one is wrong statement. Mens rea means guilty intention of the wrongdoer. Which of the following committees proposed a new chapter in the Indian Penal Code for incorporating white-collar crimes and socio-economic crimes? The answer is a Santana Committee. Okay, what are those white-collar crimes? Those crimes in which your hands are not wet with blood. You don't use very offensive things. But in the case of cheating, mischief, criminal misappropriation of property, in these things also, the element of violence is not there. But these won't be categorized as white collar crimes. White collar crimes generally will be done by the middle class people after using certain mental skills. Suppose income tax offenses, those come under white collar crimes. Now cyber frauds, all those come under white collar crimes. Who among the following was not a member of the first law commission constituted to draft a penal code? Again, it may not come because that IPC has become an history. That's why I am doubtful very much. But here the answer is BP Peacock. He was not the member of First Law Commission. Okay. A, A imports into India or exports there. Sorry. A imports into India or exports there from any counterfeit coin knowing the same to be counterfeit is guilty under which section? He has told that various sections of IPC. And now in BNS, the section has come 179 BNS. Now, what is this particular question is indicating to us? That means we have to remember section numbers, as well as its contents. For doing that thing, we have to read the entire Bear Act at least once, and after that, we will remember each and every section from index. But again, each and every section, it is a very burdensome thing. That's why I will mark out only very, very important sections which you should remember. There are two methods to remember sections. One is from top to bottom. Some of the most intelligent students remember from top to bottom. But some of the people are there who are not interested to remember each and everything. Then for them, I will mark only particular sections which they should remember at any cost. Next, I think this is the last question in this chapter. If actus non tacit reum nisi mens sit rea is a cardinal principle of criminal law, then which one of the following statements correctly reflects the above principle? Almost all the options are similar. They are most confusing. Even then, the most probable answer we will go for that. To constitute a crime, there must be actus reus and mens rea. Actus reus, R-E-A-S, it is not R-E-S, actus reus, R-E-U-S. To constitute a crime, there must be actus reus and mens rea. This is the correct answer, and this is the actual meaning of this legal maxim. Actus non tacit reum nisi mens sit rea. Okay, the other things are not correct options, but they are almost all similar. Actus reus is not actus reus is not always necessary to constitute a crime. It is wrong thing, we know it. Criminal liability under Indian law always implies mens rea. It is also wrong thing because in several offences, mens rea is not required. Mens rea is an essential element of a crime, and there cannot be a crime without mens rea. It is also a wrong answer. We know without mens rea also there will be offences. There will be a crime. If actus non tacit reum, actus reum has come. Nisi means unless. Mens sit rea is a cardinal. Mens means mind. Sit matlab is or be. Rea matlab to guilty. Now the thing has come. The actual answer is to constitute a crime, there must be actus reus and mens rea. Okay. With this, we will close this thing. This is general principles of criminal law. General principles of criminal law is there in IPC as well as in BNS. That's why these questions will repeatedly come, whatever may be the act. That's why we have to master these things. Okay. After that, there is one thing I want to tell to you. What are the subjective questions those would come from this chapter? There are two types of questions come. The first question is, what are the essential ingredients of crime? Those are five things. At the introductory stage, I told you, those are the five things. And these things you have to remember, and you have to give an elaborate answer. And the second question is, what are the stages of crime? This second question, this will be modulated in several forms. For example, what is the difference between preparation and attempt? Distinguish between preparation and attempt. Such kind of questions comes, but the main focus is only on these two questions. You take the assistance of artificial intelligence, and there you can get the answers. After getting the answers, I again caution you. You read the answers, you edit them, as and when there are mentions of sections of the law statute book, then you particularly go to that sections, because artificial intelligence, it is my experience, artificial intelligence most of the times is mentioning wrong sections. That's why you correct those sections. After that, you add one or two things from your side also. But authoritatively, you want to do that thing is you have to go to a particular authoritative text and read it and prepare your answers. I can suggest only subjective questions. Answers you have to prepare. Okay. Now with this, I will say my sincere thanks to all of you for hearing me very patiently. We will go to in the next class. We will go to the first chapter of BNS, that is preliminary. There we will read about the definitions and jurisdiction and other things. Okay. Goodbye.